Okay, so I think we're going to start. And I just want to say good morning again for those who just joined. My name is Valerie Arnould. I'm the Deputy Director of WAN-IFRA Digital Revenue Network. The topic of our webinar today is consumer data protection, and this is a famous GDPR and the evolution of the regulation. So that's a privacy part with the use of cookies and trackers. And in this context, what you are allowed to do in your digital marketing activities. I am joined by two specialists from the Piano team, Nils Riise, General Manager of the Nordics markets, and Louis-Marie Guérif, Group Data Protection Officer at Piano. So Nils and Louis-Marie will give you an overview of the topic, and anytime you can ask questions using the chat box. Louis-Marie will respond to your questions at the end. So Nils and Louis-Marie, I'll hand over to you.
Thank you so much, Valerie. Really, really great being here. We are very excited about doing this presentation. And just first to introduce myself, I'm Nils. I'm the General Manager of the Nordics. So I work with clients across the Nordic area. And we at Piano, we are an analytics and activation company. Help you collect data across different platforms and activate that data. And the reason we wanted to do this is that we're having more and more conversations around how do you actually then track this data, and how do you hold this data in a compliant way. And this is something that we'll talk more to. And Louis-Marie will also come in and introduce himself later on this. What we want to talk to you through today is a little bit more about what I will cover, the business context, and why data protection and ePrivacy, and what does that mean for your business. We'll also look a little bit into a legal context about what that entails for you, and then consequences with standard solutions, compliant data acquisition solutions, and then in the end, we'll do a Q&A for you. So if you can do the next slide here. So we'll look a little bit into the business context. And really, I want to emphasize again why we're having this conversation. This week, I've been traveling quite a lot. I'm in London now, and before that, I were in Copenhagen, in Denmark. What we saw in recent news now is that a company in Denmark just got fined because they didn't keep up with being compliant with data. And this is such an important topic to have. And I got the privilege to work with Louis-Marie, which is an expert on this, and have a conversation about what this really means. So I'm going to cover a little bit of the things that mean something here. And consumers are really in the driver's seat this time. The new data protection regulation puts really the consumer here, and the task of complying with the regulation falls upon businesses and organizations. If you're not doing that, you're failing really to comply. And what this means really here is that you have to take the consumer's right of having the right there to be forgotten. And then as we work is that businesses have a large tech stack of multiple technologies that sits on data. And given a broad tech stack, you also need to then be able to then make sure that you have the infrastructure to then make sure that you have these processes in place. So if you can click next, Louis-Marie. The next part here is the penalties, because if you're not able to comply with this regulation, that falls on to penalties for your business, which are rather high, that we see up to 4% of your global revenue, up to 20 million, which really hurts these businesses if you're not able to do so. So what we want to do today, if we click next one, Louis-Marie, is that how can you work in a compliant way? What you hear us talk a lot about in Piano is this thing called privacy by design. It requires all the departments in your company to look closer at the data and how you handle it. And there are many things in a company has to do in order to be compliant with GDPR. And what we want to illustrate for you today is how you remain compliant and the steps you have to do as a business. So this is more of the business context of why we are here today. And I'll go a little bit back and let Louis-Marie continue and show you what you should be doing. Louis-Marie, it's your help.
Thank you, Nils, and thank you to the WAN-IFRA team to having us today. Good morning, everyone. So very short introduction myself. So I'm the group DPO at Piano Indeed, and I'm not a lawyer. I come from the business area. I'm more product and infrastructure oriented DPO, and so happy to answer all your questions at the very end. What I want to start with in a very synthesized way is to have a quick legal context reminder about the two key privacy taxes principle that we have to take care as businesses in Europe. We have the Gdpr, we'll go to that, it's important, but in our digital marketing industry, where we rely on solutions that use so-called trackers, cookies, mobile IDs, tracking pixel, and so on, the most important things to have in mind and to have in the loop when we talk about privacy may be actually this ePrivacy text. ePrivacy is not yet a regulation that apply the same way across all Europe, such as a GDPR. It's in European law, it's called a directive, so it should be implemented in each national law. So we'll see that later on. We may have some discrepancies from time to time between several countries across Europe, but the basic principles are already set up in Europe when we talk about reading or writing an information on an end user's device, end user's terminal. It could be, of course, laptop, web browsers, mobiles and applications, but connected fridge, connected cars, and so far and so on. It applies to every connected device to the internet. So very important. Trackers by default are not managed by the GDPR, it's managed by ePrivacy. And then come, of course, the GDPR into the game, I would say, is that from the tracker that I use on end users' terminal to understand their behavior and to collect data, then I create personal data in almost every solution. And here we have to be very careful. We will not have the time today to deep dive into the specific comprehension between anonymous data and pseudonymized data, but all the ideas that comes from cookies, mobile IDs, end users terminal are pseudonymized data and falls under the GDPR, and we have to protect these data in a very same way as a direct email address and so far and so on. So those two taxes are linked together, and we have to take into consideration when I set up a data acquisition strategy, first-party data acquisition strategy, we have to take those two taxes into account to make sure our global business comply. If I do not respect those taxes, I would say. We have seen that very briefly with Nils. Of course, the most well-known impact of non-being compliant is the so-called fines that can go up to 4% of the worldwide turnover. And once again, the two for small breaches or big breaches, it's either the two amounts, we take the amount that is the biggest for companies. So if for small breaches, the 2% worldwide turnover is under 10 million, GDPR forces that the fine can go up to 10 million. If the 2% worldwide turnover go up to 10 million, the Data Protection Authority can take the 2% worldwide turnover that is higher than 10 million. Very important to have in mind. Second part of the risk that we can have, and that is often not that well known or in the head of everyone, and that could be much more complicated for a company to deal with as fines. There are some companies that just budget fines and that goes around that, even though we'll see after that you can have some brand shaming around. But you have to know that data protection authorities in Europe have the power to stop collecting data if it's done in an unlawful way, or if the data that has been already collected in an unlawful way, so that doesn't respect either ePrivacy or GDPR, then the Data Protection Authority can request to delete the data. It means that if you get control, and if data protection authority see that there are some problem, you can completely lose your data asset that you have built for months or years. And that's why this is a midterm and long-term strategy to think about that and make sure that the risk approach that you have take into account this risk in terms of data assets. Very important. And finally, we briefly mentioned that, of course, mainly related to fines, because then fines are sometimes public, sometimes not. You have to be aware it's not mandatory that sanctions are publicly published, but you can have some brainstorming around that. You can have some class action from organization with people. It's something more coming from the US here, but that comes into the GDPR now, this notion of class action, and of course some consumer association complaints, such you may have heard with, for instance, the Max Schrems organization, None of Your Business, that from time to time plays some actions and some complaints on data protection authorities. So 3 main categories of risk. Please work with your legal team, with your data protection officer internally to make sure that regarding your business needs and what you want to achieve at marketing level, at data strategy level, you find the right balance between the risk that you may take collecting this data compared to what the ROI that you will generate with the data collected after. So to finish this legal context, I wanted to go through what I call key European Data Protection Authority position or decision. As you will see inside this webinar, I will address specifically the topic of piano analytics and the analytics word. As you've seen since beginning of the year, analytics through Google Analytics is a very hot topic in Europe. And so here's some major decision that concerns mainly Google and Google Analytics to see what may be the issues when you don't do the job properly when checking your solution globally. Any kind of digital marketing solution, it applies to all, but specifically to the analytics in Norway regarding data transfer and following what happened in Austria or in France. In Denmark regarding risk assessment, and we just have seen earlier the risk to be considered when dealing with the GDPR, banning. So in Denmark, the Data Tilsynet called to ban Google services in school regarding data protection issues. We had a bit earlier in 2020 in Sweden, some data subject rights, very important, as Neil mentions, also in the business context. And consumer or user, consumer is more a US word in the law than in Europe. We more likely talk about visitors, users, or data subject that are not specifically consumer, but even though on an online platform, publishing platform, we consume content, but it's not mandatory paying content. So that subject, and you have to respect some rights to those data subjects. And we have some issue here with Google and Google Analytics sometimes as well, and some others in Germany for personal data definition issues, for purpose limitation issues, etc., etc. This is what I wanted to just have a quick overview about that. So now, if we deep dive into more business-oriented topic and discussions, what are the consequences when we make a focus on an analytics solution, when we use standard analytics solution, if we want to respect both ePrivacy and GDPR? Once again, the fact of respecting these laws compared to the risk is something to be managed internally with what kind of compliance level I want to achieve compared to the data I need. And we will see after that we can have both in a green area. But first, when I work with a standard solution such as Google Analytics, as it's the most spread and common analytics tool used in many websites across the world, of course, and across Europe. When I want to respect ePrivacy, there are basic requirements on ePrivacy that's by default. You cannot read or write an information on an end user's device. And we've seen that a bit later on. Reading an information could be making some fingerprinting to have a trace of the user over the time, or use server-side tracking as soon as I have an ID to match to event and recognize some traffic, some behavior. This is a reading of information. And of course, physical writing information on the device, local storage, cookies ID, mobile ID. I store something directly on the end user's device, but both are at the same level regarding the law. And by default, to do that, I either need an explicit consent, or I have to check if I can benefit from a so-called exemption when it's strictly necessary for the service I provide to my end users. This is what is written under the ePrivacy directive. So what does that mean for your business? It means that, as shown, I try to be as synthetic as possible. When the first interaction that I have with a brand, with a platform, if I have a standard tool, once again, as Google Analytics, and if I want to respect ePrivacy, otherwise I am in a compliance breach, I cannot use trackers. What does that mean? It means you lose any kind of first information and first event that you have on your platform before the interaction with the consent management platform, the consent tool, the cookie banner. So all landing pages and all first interaction are lost. Of course, then as you don't measure this first page in events, bounces can be really, really interesting as a metric in the publishing area. You have to be aware that if you don't measure the first interaction, and if you push some articles on social network, and you have a specific campaign or a specific push, and that's what you want to have is to have a maximum of reach inside on a specific page, and that people comes to this page and then go away because they have read the article and that was your objective, then you're completely potentially blind with this information as well. And of course, very important as well, especially in the SEO area and strategies, traffic sources are generic and organic traffic sources are based on so-called referrer. If you don't have if you don't measure the first interaction with the referrer included in the HTTP request or header, then you lose the traffic sources information, as even if you get a consent after, you will have all your traffic in direct access because the referrer of the second event or the first event that we measure will be the URL of your website because the user has already landed on your website. So very important to have in mind the consequences of, once again, standard solution meeting the ePrivacy requirement. When we go to the GDPR area, and one statement is very clear under the GDPR is that it should be as easy to withdraw as to give consent, which means, and this is the debate that is happening more and more across Europe, do I need a specific reject all button at the same level as accept all, yes, no, whatever the wording is? When you look at the GDPR, it's quite clear. It could take several kind of format, but when I land on a website, once again, after I meet ePrivacy, then I have this choice to make as a user, and I should have a reject option at the very first interaction without doing an additional click. That's more or less what it says under the GDPR. And quick reminder also about the fact that the consent should be freely given, specific and unambiguous, that are the legal terms to make sure that a consent is appropriate and well done under the GDPR. So what's the concrete implementation or consequences here on a CMP, once again, and consent management platform, cookie banner? So I have a clear option and yes, no option at the first level. And then even though I go to manage preferences or any kind of additional configuration on your CMP, same principle, all categories should be off, all non-necessary trackers categories should be off by default, and I should be able in a very easy way to either reject all, accept all, or choose one or two or n specific categories to meet the GDPR requirements. And here the consequences could be, in addition to ePrivacy consequences and reminder, the loss of landing pages, traffic sources, bounces, etc. On top of that, if you have a clear yes, no button, depending on your brain image, depending on your vertical, depending on the device the users are browsing on, there are several studies that are for more than 1 year now, especially in France, because the CNIL published some guidelines a few months ago, but Europe-wide, sorry, you have some studies that show up, and you may see this opt-in, opt-out rate on your business as well. The figures that comes up, even though there are studies that I can show that with a clear yes, no button, it can go up to 80% of refusal. What we can see and observe is that usually plus minus 10 points, we are around 50% of traffic loss due to this clear yes, no, accept all, reject all option at the very first level of the CMP cookie banner to meet the GDPR requirements. So the conclusion here, with standard analytics, but more broadly with standard first-party or digital marketing solution, that where you need to meet GDPR and which you need to meet ePrivacy. What are the consequences? Do you currently know, in consultation with the team, legal team, DPO team inside the company, if the tool that you are using meets the compliance level that you want to have? You need to check that some advice from us, yes, this or A/B test, this opt-in, opt-out rate based on the CMP and consent strategy, and you have to be aware of all the information that you potentially are missing, and what is the impact on the quality of the data. And I usually take the picture of driving a bike with a flat tire and without a helmet. The flat tire representing the fact that, yeah, you have a tool, but you don't have qualitative and enough data inside your tire to drive properly and take your business in the right direction. And without the helmet is that you're not secure regarding GDPR. So it could be very dangerous in both combination of the both, having a poor quality of data, in addition to be in the first line with GDPR risk, the risk or the fact of it's dangerous for your business. Is that all clear in the first place? Yeah, the question we take on at the end. Yeah. So I move forward to the solution that are existing, of course, to optimize this data acquisition strategy. I will make a focus again on the analytics part, but this could be applied to other kind of solution and first-party data solution that can benefit. We will check that from a so-called exemption regarding audience measurement. There is some legal opportunities. Once again, in this ePrivacy directive, there are some specific words, and this is some data protection authorities across Europe have published some guidelines on audience measurement that can be used without getting a specific consent for specific information, for basic and what is called strictly necessary information for the service provided to the end users. And here are provided to two specific cases for Nordics in Denmark and in Finland, but at European level also for years now, the Data Protection Board have published some guidelines on first-party analytics cookies that are, of course, non-intrusive and that can be used in an aggregated way to have key KPIs. But lots of other data protection authorities, just like Germany, France, Luxembourg, etc., have published the same guidelines across Europe. So we have an opportunity when we do the job properly, when we are GDPR compliant, and when we offer a good solution to potentially get rid of the consequences that we've just seen. How does it look like concretely at Piano, we offer with our analytics solution the so-called hybrid measurement, and it works based on the exemption because our tool can be configured in a way to both respect the GDPR and respect the guidelines from ePrivacy to be able to track with a cookie or with an identifier without a consent. And the opportunity is, of course, to measure straight directly and straight when the user is landing on your platform, whatever, regardless of it's a website on a browser or an application, etc. We are able to use our solution directly when the user is landing by respecting the law, so we can track everything we've seen and that you may lose with standard solution. The landing pages, very important in the business and the publishing area, the bounces as well, and the traffic sources for SEO management. So once again, by default, with an exempted tracker, you can use that. In case of refusal, and here we are back to the GDPR, a reminder, it should be as easy to withdraw as to give consent. Even though people click on reject or no, I refuse cookies, etc., the exempted tracker can still continue to work when it's still meeting the ePrivacy. You can still continue to use basic information to not be completely blind on what's happening on your platforms and for your business. And then we get rid of the potential 50+% of traffic loss at the very first level of the CMP. Then if you have a consent and a clear, specific, unambiguous to respect the GDPR principle of consent, you can, with our solution, what we call the hybrid, what is restricted by default with the exempted mode. When you get a consent for a specific additional purpose, that could be advanced marketing purpose, retargeting purpose, where you absolutely need a consent under the GDPR. If you succeed because you have a specific relationship with your users, with your brand, with your customers, with your brand, then if you get this consent, then our solution can be fully activable with all the KPIs that you were used to work in the advanced marketing area. So it's really the combination of both exempted measurement and complete measurement if you get a specific consent. So that's how it looks like at the very first level of the interaction of the CMP. But on the same principle, if users are going at the second level of the consent management tool to have some specific choice, it's the same principle. If you have a specific refusal on audience measurement, for instance, or performance cookies, then you can continue to track with our solution in an exempted mode to have the basic information for your business and not be blind and not be in a danger when taking some data-driven decision for your business. If you have a reject all, exempted measurement continue, and if you have a allow all or a specific approval for the audience measurement categories or any kind of other categories where you have listed your trackers, then you can go for an advanced analytics solution. So the conclusion with this kind of approach that we offer, once again, by respecting both ePrivacy and the GDPR, you maximize in a legal way the data that you are collecting, the standard and absolutely needed or absolutely necessary information that you need to provide your service and that you need for your business in an exempted way, and with the consent, the full visibility and full activability of your data. So if I may conclude on that part, and happy to take any further question after. If I make the same parallel as the conclusion with the standard solution with bikes and how this could be seen to drive your business, you have to really check the opportunities to use a compliance solution, because regarding the law and once again the ePrivacy directive, there are some opportunity to use some trackers that are non-intrusive, that respect the GDPR, to measure some first level of information without consent. And this could be very, very valuable for your data acquisition strategy. I repeat it again, all the assess all the data you may lose in terms of landing pages, in terms of traffic sources, bounces, where you're completely blind of what's happening with a standard solution on your platform, and how you can leverage that with other solutions that can benefit from an ePrivacy exemption. And yeah, here the analogy is to have the opportunity to have a good pressure on your tires to drive your business in a fast way with a good quality of data, in a complete secure way with a good helmet to meet GDPR and ePrivacy and move forward in a secure way without having any bad thought in terms of brand shaming, fines, or data asset management that we've seen in the first place. I hope I was clear enough. And if you have any question related to this, feel free.
Can you read the question, Louis-Marie, in the chat?
Let me check.
There are 2 questions, and maybe you.
Okay, what are the most frequent mistakes publishers do when applying GDPR? It's been around for some years now. Yeah, so this very first question is not an easy one because GDPR, it's 99 articles and some text before, so we'll not go through all the 99 articles, but there are key area really where publishers should be really careful. For me, the most important one is the combination of being sure that the solution that I'm using on my platforms as a publisher meets what we call the personal data definitions, as we've seen at the beginning, and any kind of data coming from trackers. And regardless of what kind of trackers, we see lots of publication from actors, ad market actors, whatever. The law is very clear: read or write information. So server-side tracking, I say that on purpose because currently it's the motto is to see what can I do server-side to not use cookies and to get out of GDPR ePrivacy. That doesn't change anything regarding the law. So personal data definition is really important. And related to that, can I answer end users' rights, data subject rights? GDPR is here to protect European citizens with what is done with their data. It's by default not for making any issue with business, it's to protect citizens. It's our European value put in a text to protect our personal data. And if you as a company cannot answer data subject right, which is the most fundamental for me things inside the GDPR. If you have someone coming to say, I want to erase my data, I want to access my data, to be able to do whatever I need to do with my data as a citizen, if you cannot reply to those requests as a publisher with a solution that you're using, then it's a big issue. So for me, that's the first set of things that you need to be careful about. And then, of course, as you've seen since the beginning of the year, this is all these current data transfer issues that may happen with some solution. And related to that, for me, it's the second pillar is what I call the generic transparency. GDPR is clear in some articles as a publisher. It's very common, and you have seen that in some data protection authorities decisions that always, or in almost any cases, the DPA, Data Protection Authority, is saying the publisher is data controller. It's the role, it's the responsibility of the publisher to choose the solution and to implement the solution on their platform. The publisher cannot say, oh, I was not aware that this solution was running on my platform. It no longer, it may have been an argument at the beginning of GDPR 2018. Now you can see that on almost any decision, it's no longer a valid argument as a publisher. You are responsible of the solution that you are implementing and using on your platform. So responsible for the data you collect, you process, with sub-processor, with providers, but you have to check the warranties, the quality of those providers to make sure that your business remain compliant. And in this transparency area, to really check the roles of the actors and the providers and the services that you get is really, really important.
Louis-Marie, could I just add something to that from business side that I
Sure.
see also is, I think one thing is definitely making sure that the solutions that you work with have this privacy by design and that they can work compliant. Where I work is very also in the organizations of the publishers. And what I see very often is that data remains silos in different departments. We'll have a department working with CRM data, behavior data, social data, advertising data, and these remains very siloed. What we try to work with these publishers is about unifying these data sets. And this is the key point of having a DPO for your organization, making sure that that department, if they work silo with that data, what does that mean in terms of the privacy? And having an owner of making sure that those departments are then keeping that in mind. And I would say a big step here is on unifying data so you're in control and making sure that the first goal of everything that they do is that the data remains compliant and that the user has the right of them being deleted across these different data silos. I think that's important to mention here.
Exactly. And we didn't talk about data ownership also in the transfer area, but I will talk about that regarding data transfer. This is a key element. As a publisher, I need to keep the control on my data. And regarding the contractual clauses that you have with your provider, some providers are reusing their data or reselling their data, the data of the publisher, and most importantly, the data of the end users that the end users were willing to give to the publisher, where they have a one-to-one relationship. This could be a very problematic area. This ownership, data ownership and control.
Okay. So
yeah.
There are some, maybe we can, because there's a big question from Vivian about the KPIs can be tracked under, but maybe we can finish with that, because there's Tam has a question about the implication of data transfer issues, and it's in understanding. Can you read? His understanding is more about technical infrastructure and than UX and or.
Yeah. So it's not an easy topic, and I don't know how much lawyers or the level of legal people in the room, but data transfer means globally, or the Gdpr defines data transfer as, or the principle is that the protection level that we have in Europe for European citizens, but again, should travel if the data is leaving the EU. So we have some countries, just like Japan, just like Argentina, Switzerland, where the European Commission is saying the local law is in accordance, is adequate to what we have with the Gdpr. So we are kind of the Gdpr can go broader in a sense to Europe, but so it's both physical and non-physical things, the data transfer, because of course the main stuff and the issue that was in the first place for Google Analytics is the fact that you have a physical flow from data from Europe to a non-adequate country. In the specific case of Google Analytics, the US, but you have data servers in countries across all the world with other countries that are not adequate regarding the GDPR. So it's not a US US thing. So of course, data transfer concerns the physical transfer of data from one data center, a physical place, to another. The digital is not a beautiful word, whereas the data is stored in the cloud. The cloud at the end is some physical data server, somewhere. And on the same way, you have also some stuff to be careful about. That when I access the data, so even though the data is stored inside the European Union, when you read an information, you read the data, it's considered as a processing, so as a transfer under the GDPR. So it's a more global things to be careful. But you have some risk assessment to be done also with so-called transfer impact assessment under the GDPR to monitor and check if you have an issue or not regarding the GDPR regarding data transfer. So
ultimately, unless Google have data servers in countries that are compliant to GDPR, it's not a viable solution in the short term to use GA, right?
So I may not talk for GA in this place, but regarding data transfer, this could solve a part of the issue. Having some physical and store the data inside Europe, it could solve a part of the issue. But if you look at the global GDPR, there are more issues than just the data transfer. Data transfer, we make a focus of data transfer in this year of 2022 because of the decision from Austria, in France, and more globally, as we've seen also in Norway or stuff like that. But GDPR, once again, it's 99 articles that you have to comply with. So transfer is a chapter 5 of GDPR. It's a key chapter of the GDPR, but that's not the only one. So you have to check with GA. Does it meet, as we've discussed, the personal data definition based on cookies, etc.? Does it mean the end user's rights? So can you answer data subject requests with GA? What about ownership issues in your contract, if you have a specific contract? Because usually terms and conditions under GA are not that clear between the purpose of analytics and the purpose of advertising, etc., etc. There is a list of points that you have to check with your legal team, with your DPO, to check if you can use, eventually, I don't have the answer, GI in a compliant way. I have an idea, but it's not.
Okay. That's an easy question. So let's go back to, so first with the KPIs that can be tracked under exempted measurement. And then after, Nils, maybe you can share with Daniel your understanding of best practice with the companies that you work with about the ownership of data inside the company and who is in charge of data warehouse, how you see best practice in organization. So, but first, data governance, yes. So, but first, let's go back to, sorry, Vivian, we went away. We took some time to respond to you. So this isn't an easy one. Which KPIs can be tracked under exempted measurements?
That's a really, really good question, because so I don't have by heart all the details of every guidelines of every data protection authority across Europe that have published some guidelines to use audience measurement, for instance, without consent. But basically, in France, the CNIL gave some examples of what could be done, and we have. When we thought about audience measurement few years ago, or statistic, it's really in lots of guidelines, you have this statistic data or statistic word used. You can use, or that's our standard offer, at least on Piano Analytics. And this after will depend, it's the legal beauty of the thing is that I remember ePrivacy thing. You can use without consent, was it strictly necessary for the provision of the service requested by the end users? So it's not an easy phrase. You can put a lot of stuff inside this, what is strictly necessary, or you have to raise question internally. And here, please involve your DPO and legal team. This should be a combined work with business teams and legal team, or DPO and or to define as a publisher what is strictly necessary for the service provided or for the provision of the service requested by the end users. But basically, we discussed on our side with the CNIL to see what could fall under as an audience measurement under that, and they gave some example in their guidelines, and we have all the content KPI. So to make sure that you don't have any breach in the navigation of the users, you are able to analyze and collect pages, clicks, events regarding content to make sure you drive as a publisher. Your idea is to provide content to end users, right? And if you the users request to consume content on your platform, so you should be able to detect if there is any breakdown in your navigation path. And this is a first of kind of KPI that you can definitely measure the content KPIs, and we have plenty of KPIs related to content. Then there is a second area where it's definitely okay to measure. It's everything related to or to the technical KPIs. So we enrich data when we work with our analytics solution, and we provide our customer with some key information about device recognition, etc. So you have the opportunity to check from what device, from what operating system, etc. the users are coming from, to use also this segmentation and to make sure that the service you provide to the end user is operational, I would say. If you have not this information, then you can miss some breakdown on some specific OS, on some specific devices, and you need to have this information. And then we have some other aggregated KPIs that we can offer, and you can follow up the sometimes seen as basic metrics, but when at least I talk to customers sometimes regarding, and we'll discuss that with Nils after, the data convergence inside the company. We are happy to measure the standard number of visitors, visits, time spent, etc. The things that is seen as really basic, and you can say, oh, them with the exemption mode, I'm back in 2000 with the pre-age of analytics, right? But at the end of the day, this is we can observe that lots of customers are still driving some key decisions inside the company with this kind of basic KPI: visits, visitors, time spent, number of page views, etc., etc. And this is definitely, in addition to organic traffic sources, as I mentioned, also you can drive quite a lot of or get quite a lot of information. This should be, I think, potentially presented in a separate session with inside the tool. But yeah.
Thank you, Louis-Marie. So Vivian, back with this question. So you declare these KPIs as legal basis or as technical necessary?
This is a good question as well, and to be definitely double check with your DPO and your legal team internally, because there is no black or white answer. There are some people that put the exempted analytics, audience measurement, or exempted solution in the strictly necessary categories where you cannot deactivate that. There are some people that continue to use an audience measurement category and inform the end user that we, inside this category, some tracker are used in the exempted mode, etc. So there is plenty of use cases. And from publisher to publisher, you can see, for instance, piano analytics as an example, inside different cookies categories inside the content management platform.
Okay, so maybe we can go back on Daniel's questions about the data governance. Nils, you work with Nordic companies. They have the reputation to be extremely respectful of the user data. So I guess that you've seen some best practice in those publishing companies.
Yeah, absolutely. I can maybe just repeat the question here. So who in the company should be the owner of the data and who's in charge of the data warehouse? So this varies from company to company, but I see those that I believe are doing it right. This is my personal thinking on this. So I work also in Oslo with a lot of data engineers on our platform. And you have teams that wants to do a lot of stuff at the same time, but you need at times somebody holding that a little bit back based on the rules, right? I think that for this to work optimally, you need the right people that knows how to be, for example, the data engineers and are optimizing this and what the capabilities are. We also then need an owner of then the privacy that is then looking into, are these things that we want to be doing compliant overall? of what GDPR means and other things. So I think it's the combination of those two working together and figuring out what keeps in mind of privacy and what keeps in mind of what's important for my business. So they are unified.
Okay, thank you very much. Any more questions? I've shared some resources that you have on the Piano website as well that I use myself on, like this guide on putting privacy first. That can be helpful. I have a tricky question for you, Louis-Marie. Where do we stand in the, this ePrivacy regulation? When do you think in time it might become really more strict, more that we have to apply it?
To anticipate, yeah.
It's still, it's still not.
It's still not live. It's still under discussion. So, to my knowledge, the last draft of the last version draft was February this year, and under the European process, this is a trilogue phase between the European Parliament, the Council, and the Commission to agree on the text. I don't have any new dates to share today, or to my knowledge. I know that there are also some discussions with the new, you may have heard about Digital Market Act, Digital Act, and etc. And there are some, I've heard that there are some discussion to see if actually the ePrivacy regulation could be like directly managed with the Digital Act directly. Maybe I'm mistaken on one of the 3 or 4 new acts that has been released or about to be released. But yeah, it's still an ongoing discussion. There are no so concrete timelines about this ePrivacy regulation, but the principles that are live, and I didn't mention that, till 2002. ePrivacy is a directive from 2002, revised in 2009, and implemented in national laws several years after, 2013 in France, 2021 in Germany, for instance. So you see there is some discrepancies, but the principle remained the same, and it will not, that's maybe my conclusion, if the idea is to see how I can prepare my business from what we see in the draft of ePrivacy regulation. This is exactly what I presented today, and this is actually exactly the same principle. You don't have the right to do anything if it's not strictly necessary or if you get a consent. You have in the draft of ePrivacy regulation an exemption for the solo purpose of audience measurement if it respects the GDPR. So it's stated in the latest version of the ePrivacy regulation draft. Starting from now, let's see how the European institution will move regarding that topic. But my recommendation would be to take that as granted, even though it's not officially applied to everyone at the same level with the same condition right now. This is the sense of history, I would say, on that topic.
Thank you, Louis-Marie. Okay, do you want to add something, Nils?
No, I think we covered quite a bit on it. I just would want to say, basically, is that we've been with GDPR now for quite a while, and as Louis-Marie, ePrivacy goes back to 2002. I mean, we're still seeing now fines coming and happening in Europe. What we want to do is to then share basically what are the things that you should be applying to your business. Well, that's easier said than done. But I think it really means that what we like to do is that work in close collaboration. I think I learned so much on this topic working with Louis-Marie, and we're so lucky to have him. And by that, we're also then able to be a support system for these companies that want to make sure that they are being protected. I think that's important. Work with solutions that you are trusted in this environment.
Thank you, Nils. Thank you, Nils, and thank you, Louis-Marie. That was a very interesting conversation and a lot of information. By the way, you will get a recording of the video so you can share with your colleagues. And on that, I'll thank you very much for your participation. And I hope to see you soon in one of our other events. And I wish you all a very good day. Bye.
Have a good day. Bye.
Thank you so much. Bye-bye. Merci.
Bye.